We are excited to have this conversation with you today about the CCPA and the application to nonprofits. Like Nate and Margaret said, my name is Sushila Chanana. I am a privacy and IP litigation attorney here at Farella. However, prior to embarking on a legal career, I spent some time in the early to mid 2000s working as a cybersecurity consultant at Pricewaterhouse. So what I did at that time was pretend hack legally into systems to expose security vulnerabilities. So it's quite rewarding to now be on the other side and feel like I've come full circle to be on the legal side of privacy and cybersecurity issues. And I'm very excited to talk to you guys about this today.
And I'm Nate Garhart. I also focus on privacy and IP, though I try to stay out of the litigation side of things with limited exception. But I work on protecting IP, notably trademarks and copyrights on behalf of clients. But today we're going to be focusing mainly on privacy with a touch on IP at the end, just to live up to our title. But with that, we'll get started. So this is just generally what we'll be discussing today, generally what people think about when they think about privacy. The California Consumer Privacy Act, of course, and I'm sure a lot of you heard or will get some information from you about the fact that it doesn't apply to nonprofits. So why is it relevant at all? Well, we'll talk about that. What, if anything, should you be checking or considering in connection with your privacy obligations? We'll be talking about data security requirements and data breaches that arise and what to do in connection with data breaches, or at least what the law here in California looks to. We'll also look quickly at the California Privacy Rights Act, which is a new piece of privacy law that's on the upcoming ballot. And finally, I'll touch on a couple of updates in the trademark, copyright, and patent area. So what are the generally understood privacy rights of individuals? Well, if you look at this list, if you followed it at all, it really reflects what's largely in the GDPR, which is Europe's privacy legislation. And because of that legislation, and to some degree, it's a mirror of what was expected, but people generally have a belief that they have certain rights in connection with their data. Generally, people think they should be able to access their personal data, correct inaccurate information that companies have as far as their personal data, be forgotten with or without asking even, to limit the way information is processed, to get their data and actually transfer it to another company, and to object to the use or sale or other actions in connection with their data. Now, do they have all these rights? In some jurisdictions, they do. In Europe, they certainly have all of these rights. Here in the United States, it varies.
So not surprisingly, California is leading the way in terms of protecting consumers' personal information. You will see that California and a couple other states have enacted and signed consumer privacy laws. A good portion of the country has not, but we're seeing some progress. And we anticipate the changes here to be going towards more laws that are similar to the CCPA. And of course, there's also a federal privacy law that's being discussed, but DC has other things on its mind. I don't see anything moving too quickly over there.
I'm going to have to agree with that one. So what are we looking at right now? Right now, we're really considering in the privacy landscape as California companies, the California Consumer Privacy Act, which came into effect on January 1st of this year, the new California Privacy Rights Act that we'll talk about later, some legislation that covers data security, and finally, data breach notification laws. That is, if you have a data breach, what do you have to do? There is a California law that speaks directly to that. So a quick poll. When I talk about the CCPA, what do you think of? All right. I'm getting some responses. Excellent. I'll give it 5 more seconds. I know these are tough ones. All right. So most people would like to hear more about the CCPA. That's good. You've heard of it. You need to apply. You need to hear more about it. And that's great because that's what we're here for. All right, so a quick refresher about the CCPA. And I should preface this by saying we don't go in depth in this presentation into everything that the CCPA requires of a company. We're really looking at specifically issues that nonprofits need to consider or facts that nonprofits need to consider in determining whether the CCPA applies to them or not. That said, Sushila and I have both given numerous presentations on the workings of the CCPA and the requirements of the CCPA, and we'd be happy to talk to you about those, give a presentation to your group, or just talk you through the issues at your convenience if that is something you need some help with. But today we're going to be focusing on when does a nonprofit have to be concerned about the CCPA? So a quick refresher on the requirements of the CCPA as far as who it covers. It applies to for-profit, right in its definition, right in the definition of its jurisdiction. It says it applies to for-profit companies collecting information from California residents if that for-profit company, A, has annual gross revenues of $25 million or more, or B, collects information of at least 50,000 California residents, households, or devices annually. And let me just very quickly, the difference between a resident, a household, and a device. So for example, with me, you might collect my email address. You might also collect my home email address, which is the email address of more than one person than just me. And you might collect information from my iPhone. If you are collecting information from those 3 sources, that is 3 of those 50,000, not just 1 because it's me. So that's why it lists those 3 separate categories. But at any rate, again, $25 million or more, 50,000 residents, households, or devices or more. And then the third one, which is much less likely with most companies, is getting at least 50% of annual revenue from selling the personal information of California residents. This is really going for, sellers of email lists, things like that, companies that really directly form their business and base their business on the sale of personal information. But again, we go back to the beginning, this is about for-profit companies, not about nonprofits. But does that mean nonprofits can ignore the CCPA? The answer is no. There are a couple of bases on which a nonprofit could be subject to the CCPA. First of all, if the nonprofit shares branding with a related for-profit company, so if it is a subsidiary of or a company related to a for-profit company that is subject to the CCPA, the nonprofit would be subject. And the classic example of that would be the Nike Foundation. Nike Inc. Is it Nike Inc. or Nike Corp? Anyway, Nike certainly is subject to the act, and its nonprofit charity shares its branding and certainly shares certain information from the company and is subject to the CCPA as well. The other situation is where the nonprofit is collecting information in connection with a joint venture or other contractual relationship with a for-profit company. So that's going to point to looking at the companies that you're working with and being sure that the nonprofit is not subject because of that information sharing or the terms in the contract itself. And then the third, and Sushila is going to talk about this a little more, the nonprofit agrees to comply with the requirements of the CCPA in a contract with a third party. So this is becoming more and more common because companies see their requirements under the CCPA as calling for them to make sure those that they share information with to protect that information. And often those companies are working with nonprofits.
So very quickly, nonprofits, not surprisingly, work with vendors, third parties that host data. So in terms of what nonprofits should be looking at with respect to vendors, nonprofits should anticipate potential additional costs to cover CCPA compliance requirements by vendors, additional time constraints, and changes in the way that data is managed. Just briefly on this point, I highly advise the IT folks, both on the nonprofit side and on the vendor side, to have an open discussion and a thorough discussion about CCPA compliance, especially if it impacts the vendor. Second, data processing agreements may require nonprofits to abide by CCPA compliant data collection and retention policies of for-profit partners. And then third, if you have a joint venture with the for-profit business, both entities, the nonprofit and for-profit entity, will likely need to agree on how the data will be collected, stored, used, retained, and or deleted. So I've seen many contracts in which this is clearly laid out upfront with the hope that everything is covered, and that is a great starting point.
Agreed. This is the point of this is really the more that we get into this privacy realm, the more you're working with third parties in connection with personal data. So the classic example would be if you don't send your own emails, but instead use something like Constant Contact or the like to send marketing emails. Those contracts are going to be the very contracts that you need to look very closely at to see if they create requirements for you under the CCPA or other privacy issues that you need to deal with and pay close attention to. And once you do, as Sushila said, you'll be looking at getting your IT department involved to make sure that you're treating this data as you're required to do. So just a quick touch on the CCPA final regulations, just because they came out recently. It's interesting, they were labeled as the final regulations, and they changed a couple of things, nothing that I would call out specifically beyond listing them here. But then interestingly, just 10 days ago, the Attorney General's office offered up some new regulations. I guess they'll call them the final regulations, but those are out for comment right now. The most interesting one of those, if you see the fourth bullet point down I have here, no offline notice necessary. That was about the situation where you're collecting information from people in a physical location. So people are showing up to your entity and they're filling out a form and giving you their email address. Well, they said, look, you don't have to give them the full privacy policy on paper or anything like that. You can just point them to the website so that they can see the privacy policy. And I thought that was very reasonable. Well, the new regulation that just came out said, well, we kind of changed our mind. That's not enough. Instead, if you give them something, if you collect their email address or other personal information in person, you have to give them notice of how they can opt out of the sale or other use of their personal information in person on the spot. So we'll see if that gets through, but the point of this isn't to belabor every specific regulation and what they call for, but it's that we're still up in the air on these things. We really don't know everything about what the Attorney General is going to enforce, what the Attorney General sees as important. And as we'll talk about later, we've got a new law coming. And so things could be up in the air again. So unfortunately, the lesson that we take away from this so far is companies need to do their best, but don't expect that we've got the answers at this point.
So not surprisingly, the CCPA really forces companies to limit the type of information that would be compromised during a data security breach, because the assumption is it's going to happen. It's most likely to happen, whether you're a small, medium, large company. So what the CCPA says is that your companies that are subject to the CCPA must implement and maintain reasonable security procedures and practices. It also allows for a private right of action for a breach if those practices were not, quote, reasonable. And indeed, it allows for statutory damages of $100 to $750 per plaintiff, which is just a calling for a class action lawsuit. And that's been the trend so far. And I'm happy to get into that later on as well. So the first question that I have clients ask is, what is reasonable? So the CCPA doesn't define what the word reasonable is, and it's yet to be determined by the courts. But we have some pretty good guidance from the 2016 California Data Breach Report from the California AG's office. And in that report, there is a reference to the 20 security controls published by CIS, which is the Center for Internet Security. Some examples include, taking an inventory of your hardware assets, continuously looking at your vulnerabilities, managing those vulnerabilities, understanding what your data recovery capabilities are. And that includes everything from knowing who would you contact if there was an issue with data that had been compromised. What are the steps? Who from IT, from legal, from HR, from the business side would be involved? At that time, the then current AG, Kamala Harris, noted that a failure to implement all applicable controls constitutes a lack of reasonable security. It's not yet clear if the current AG will follow this guidance, but it's a pretty good starting point. And I'd like to use this opportunity to share with everyone what I call a cautionary tale. And that is many companies wisely hire forensic firms to do what I did before practicing law, and that was to come in and do these pretend hack exercises to find out where the vulnerabilities are so you can patch things up, make sure everything is secure. And that actually would, I would argue would be a reasonable measure taken by a company under the CCPA, kind of reasonable and preventative measures taken by a company to make sure that the security is tight, the procedures are good. But the cautionary tale comes out of a recent order out in Virginia in which Capital One suffered a data breach. And prior to the data breach, Capital One actually had a forensic firm that did the vulnerability check. And then subsequent to the data breach, used that same forensic firm to now figure out what had been compromised, what the hackers had taken. And the other side the plaintiffs wanted to see the security reports, both of them, the initial one and the post-breach one. And defendants argued, well, this is privileged. Our attorneys asked for it. And the judge disagreed. The judge said, nope, it's the same forensic firm that you used to do the routine checks prior to litigation and not in anticipation of litigation. And then since you use the same firm under the same statement of work, contract, the scope is the same. And in fact, the only difference is that your outside counsel asked for the post-breach firm to come to them instead of the client directly, but that doesn't matter. The privilege does not apply. And Capital One has to produce this forensic report. So the big takeaway there is if you're going to use a forensic firm initially to do the routine checks, and then you do have a breach, hire a different forensic firm. Make sure it's a legal expense. The judge in that case also noted that, well, the forensic firm was a business expense. They looked at the accounting records, not a legal expense. So these are minor details that the judge really focused on. And it's not yet clear, if a judge here in California would follow the same path, but everyone's on notice that this has happened. And so I'd like to share that story with folks.
So Sushila, should companies be going through this exercise, whether the information is going to be privileged or not? Should companies be going through this exercise of the pretend hacking and the testing for vulnerabilities? Is it worthwhile, or is it just too big a risk? Because if you have a vulnerability, well, now it's documented.
Well, I think on balance, you should. It is a significant and important way to show that you take security seriously and you put money up for it, because as part of that process, IT is involved, HR is involved, legal is involved, business units are involved, and you can have a paper trail that shows all these folks were involved. This is what each one did. This is how long it took to complete this process. Even if we discovered X, Y, and Z, these are the measures we took within a reasonable time frame to make sure that it was addressed. And so that documentation, that record, if you're forced to produce it during discovery, can be very powerful. I understand the risk of, you're exposing yourself to some vulnerabilities, but on balance, it's very prudent. So I do advise clients to go down this path.
And while I know one of us is going to touch on it later, we're talking about the CCPA right here and implementing its requirement to implement and maintain reasonable security procedures and practices. But is that the only basis? So for example, if our nonprofit companies listening in are saying, well, I'm not subject to the CCPA, therefore, do they not have to worry about reasonable security procedures and practices?
No, not at all. In fact, the trend and the expectation definitely of consumers is that you will maintain reasonable security practices in terms of protecting my personal information. Nonprofits, again, work with for-profit entities, whether they're third parties or subsidiaries or parents, et cetera. And they might have a requirement, nonprofits, under those contracts to do exactly this and take reasonable measures.
So we'll be talking more about the CCPA and its requirements, but everyone should take away the idea that even if not subject to the CCPA itself, data security is important, and these controls and implementation of practices and procedures are important for everybody to protect the data and to protect the company from various bases of liability.
Right. So the CCPA has two arms, and that's the one side is the enforcement arm, which is exclusively limited to the AG's office. And these are violations under the CCPA. The damages range to anywhere from $2,500 to $7,500 per violation.
Can I jump in really quick, Sushila? Yeah. I'm sorry. So this is one of the, when looking at the AG's enforcement and the violations that Sushila is talking about, this is for violations not in connection with breaches, but instead, for example, not disclosing that data is sold in connection with certain activities, or that data is shared to certain types of companies in connection with certain activities. The CCPA lays out the disclosures that have to show up in the privacy policy, and the violations that are separate here that the AG can take action on include all of those disclosures that need to show up and practices and policies that need to be disclosed to consumers. The other side is on the breach side, and Sushila will talk more about that.
So thanks, Nate. Let me just briefly focus on what the AG's office has done in terms of violations. And again, the AG's office is looking at whether you are subject to the CCPA, what your privacy policy looks like. And so already the AG's office has sent out notices of CCPA violations to companies. So far, they've only gone out to companies that are have an online only presence. Those notices are confidential, so we haven't seen them, but the AG's office has revealed the following, and that is that they targeted multiple industries and business sectors. They focused on businesses that were missing key privacy disclosures or a do not sell link. And an interesting note is that the targets of the letters were identified primarily by consumer complaints on social media like Twitter and Facebook. So they're watching what folks are saying on those platforms. And the reason the AG's office sends out these notices is that the CCPA requires the AG prior to any enforcement action to give a business 30 days to cure. And depending on the business's response to the AG's letter, the AG may decide to, bring suit, open an investigation, etc. So far, the AG's office has said that its focus is on protecting minors and other vulnerable populations, and looking at any situations where there's a wide-scale impact on Californians. And they've also shared that what else matters to them is the type of data involved and what the harm was.
And interestingly, to date, I'm not aware of a nonprofit that has, there hasn't been any published discussion of a nonprofit that's received any kind of enforcement notice that I've heard. Have you heard anything, Sushila?
No, I have not. But again, those notices were confidential.
Yeah.
Who knows
we'll see
what's to come. Yeah.
Right.
So I did want to mention.
Oh, I'm sorry.
This range, if we could still stay on this slide, this range of 2,500 to 7,500, really what the AG's office has said here is, what's the impact? Was it intentional? Did you ignore us when we first brought this to your attention? Did you ignore the complaints that were coming your way? And if you did, then that number is going to be higher, right? It's going to be closer to 7,500. Okay, so just switching over again on the same slide to the private right of action. And this is really limited. The AG's office has made clear that it's really limited to data breaches. And this is, you've got a situation where per data subject, so per individual, damages are anywhere from 100 to 750. And not surprisingly, one person isn't going to go running to court for over $100. This really screams for class action litigation, and that's exactly where we are. We'll get into that in a couple slides of what the class action CCPA landscape looks like. Significant damages, and we can go to the next slide. And these are statutory damages, right? And that is a big, big deal because you don't have to prove any actual harm. And this was the AG's effort to address what was a problem for plaintiffs in the past. Plaintiffs in the past have had significant issues proving the harm. If you can't prove that anything happened to that no money was stolen out of your bank, or no one's harassing you via phone or email or mail, then what's your real harm? And so there's an assumption under the CCPA that you have been harmed. So that's why it allows for statutory damages. And under the private right of action, you have to show that the breach related to non-encrypted and non-redacted personal information and the company, the target, or I should say the defendant, the breach was due to the defendant's unreasonable security procedures and practices. I will also add here that earlier I mentioned that the AG is required to give a 30-day written notice to cure. So are private individuals. So far, most plaintiffs have completely ignored that 30-day requirement. In most of the complaints, they don't even mention it. A couple where I have seen it mentioned, it'll say, we sent this notice letter 2 days before filing the complaint. Depending on how we respond, we reserve right to how they respond. We reserve right to damages. But the assumption is, whatever the response is going to be, it's not going to be good enough. So what I've told clients is don't rely too heavily on this 30-day cure provision, because the way the CCPA is written, your potential plaintiff is required to provide you with a written notice to identify the specific provisions of the CCPA that plaintiff alleges the defendant has violated. And if it can be cured, it has to be cured in 30 days. And then the defendant, that company, must provide an express written statement saying that the violations have been cured and no further violations shall occur, which is a very tall order, to make that promise. And then, let's say you get that and you're satisfied with it, which most plaintiffs won't be. But if you are, if there's a breach in that express written statement, that consumer can enforce the written statement and pursue statutory damages for each breach of that written statement, along with any other CCPA violations. So again, it's not a real safe harbor in my opinion. And, again, plaintiffs will argue that there's no cure here. The cat is out of the bag, the data's out. What can you really do? Until we see courts give us some more guidance on that express written statement for that 30-day cure period, I would not rely too heavily on the safe harbor provision. Thanks, Nate. Okay, so in terms of the current CCPA litigation landscape, since January 1st, about a little over 32 class action lawsuits have been filed. They're all class action lawsuits. Majority of them, about 70% of them, relate to negligence or non-data breach claims. But again, the expectation is a good portion of them will be tossed because the AG's office has made clear that the private right of action is limited to data breach claims. And just by way of example, a non-data breach claim that's come in is, you've got a defendant who disclosed plaintiff's personal information to a third party, but did not tell plaintiff that it would be disclosing that information to a third party. Well, the allegation plaintiff has made is, well, that's unauthorized disclosure, so that comes under the CCPA. We expect, early dispositive motions to get rid of cases like that. Briefly, most of these complaints, they're not just violations of the CCPA. Some of the other claims we've seen are invasion of privacy, unfair competition law, Section 17200 violations, Computer Fraud and Abuse Act violations, Stored Communications Act violations, negligence, breach of contract. So they're just really throwing a lot out there. And in my opinion, plaintiffs are kind of wanting to see what sticks. So I think we are okay to go to the next slide. And just to wrap up the data security and breach section, there is a CCPA, California Civil Code that applies to nonprofits, and that's when there's a data breach and what the notification is. And this requires the company to lay out, the entity to lay out when it happened, the timing, and it does only apply to California residents. So again, IT and HR and the business unit needs to figure out, who's at issue when this breach happened, how many of these folks are California residents. And then frankly, we'll have to look at if there are other states that have similar data breach notification laws as well and comply. And then it requires a full analysis of the implicated data. So this is something that nonprofits directly should be aware of.
Absolutely. And data breach, you read it again and again. It's not a question of if, it's a question of when. And so in connection with data breaches, there are 50 states and the District of Columbia have their own laws on what needs to be done and what triggers those requirements. The number of residents of the given state whose data has to be impacted before you have to provide a notice, what needs to go into that notice, et cetera. So the two things I like to tell companies when we talk about data breaches is the minute you're aware of a data breach, while you have to disclose it in an orderly fashion and sometimes very quickly, don't disclose it right away. First of all, plug the hole first. Figure out what that vulnerability was that enabled the information to be accessed without authorization, and plug that hole. Because if you don't, they're going to continue to dig. They're going to put methods in to get back in after you plug the hole. So first, figure out the hole and plug it. Second thing is, yes, start analyzing the data, but also start analyzing these laws. So unfortunately, that does mean a call to counsel at that point, because you're going to have to look at 50 states and figure out what to do in 50 states, 51 jurisdictions, including the District of Columbia. But that is something that we have a good bit of experience with. And while it's not a fun exercise, it is something that can be gotten through in a fairly expeditious way. The key is really IT and understanding that data. And you'll hear us say that a lot with the CCPA, with privacy in general, with data breaches. A lot of it is really about the IT department and understanding all of the data that you have and having practices in place to control that data.
And I just wanted to add a couple things on that point, Nate. And that is this is another reason, frankly, you want to have a forensic firm going through this exercise prior to a breach, because one of the things that happens during that process is you figure out what to do when a real breach happens, and what steps need to be taken. And as an attorney, you know, as much as I enjoy speaking with other attorneys, the key here are your IT and HR folks, the technical folks. They're really important on this. This is a collaborative effort for companies.
Excellent. All right. Well, enough with the CCPA for a time. Let's go on to another acronym. How about the CPRA? So when I bring up the CPRA, what do you start thinking about? All right. I'm going to end it now. So we've got one first responder in the room. Excellent. The lion's share of people are saying, oh, geez, here we go again. And you know what? You're right. Oh, geez, here we go again. So let's talk a little bit about the CPRA. So the California Privacy Rights Act is on the November ballot. It is going to pass. There's almost everything I read says it's in the over 80 to 90 percentile that it is of people who are likely to vote for it. So it's very expected to pass. It actually creates a floor of privacy protection in California. It has a provision in it that says that no legislation is valid if it undermines or has less restrictive policies in it than those in the CPRA. So it creates a floor for privacy protection. It creates a whole new category of sensitive information that has a different additional protections on it. It requires the ability to opt out from selling or sharing. The CCPA only has an opt out from selling, not sharing, but this extends that. And it gives consumers, we talked about those early rights, it gives consumers additional rights to correct their information and to transfer that data to other companies. So if Google's got all my data and I want my new account at Apple to be up to speed very quickly, I can ask Google to send my information to Apple. I don't know how that's going to work in practice, but that's what the law says. Couple other facts about it. At the end of the day, though, again, we're not going to go too deeply into this, and it's difficult to do so because, again, it hasn't even passed yet, and we don't have any regulations. But at the end of the day, the one thing it does not change is it's still expressly for-profit companies only, with those exceptions that we talked about previously. So the key is still looking at those contracts. Unless you have a subsidiary or a parent company that you share branding with that qualifies and is subject to the California privacy laws, then you won't be either. And again, you need to look at your contracts to make sure something else isn't dragging you in. So now that we've talked about all this stuff and droned on about all the bad news that's in it, what is it that you need to be doing to make sure that you're in shape in connection with these laws to the extent that you do end up subject to them?
So before I get into my little list over here on the left side, I do want to share that most companies over retain records and information, and a good portion of that is personal information. So number one, know your data. Don't over retain records. If you have records from 20, 30 plus years ago, why do you need them? Go through that exercise to figure that out, because if you have it sitting there, it's vulnerable and you have to protect it. And so your exercise in terms of what you're going to do and the efforts you're going to take is just more magnified, and it's larger. So really think about the data you have and whether or not you need it. Second, update your policies and procedures, especially if your vendors and folks you contract with require those policies and procedures to be compliant with the CCPA. As I mentioned, organize your records, the deletion requirements, bolster your security. We've already talked about what measures you can take there. Check in with your vendors. Make sure you have an open and very early discussion about how data is handled when it comes to your vendors. And so as a litigator, I understand everyone, they've got a business to run, you've got folks are emailing, you've got to provide responses, but be careful about what you say in terms of your treatment of data. And most likely, I suggest checking in with some kind of counsel. It doesn't have to be litigation counsel, but some kind of counsel before you make certain promises about what you're going to do with that data, because what you don't want is that email to be exhibit one in a depo or a trial, and you have completely failed to do exactly what you said you would do in that email.
That's a really good point. And related to that is being careful with your policies as well. So almost every website should, but almost every website does have a privacy policy. Make sure that privacy policy reflects what you're going to do and what you actually do with data that you collect. So because of the initial slide about privacy expectations that people have, it would be very easy to go to a very data protective company that's subject to the CCPA and say, hey, I'm going to grab their privacy policy and put it on my site because they'll be up to date and they'll certainly be complying with the CCPA. And if I have to do so because of my vendors or whatever, at least my privacy policy is in good shape. Well, your privacy policy might comply with the CCPA, but it wouldn't necessarily comply with or match up with what you actually do. And that can lead to liability on its own. It basically amounts to misrepresentation or false advertising of a form. And so it's not something to go out and just grab a policy from somebody else or just put up, have your lawyer draft the most CCPA compliant policy of all time, whether you are required to comply with the CCPA or not. That certainly could have some benefits, but at the end of the day, your policies need to reflect your actual practices. So make sure they do. All right, so that's enough about privacy for a little bit. How about one more poll? And how about some IP? How do you feel about some IP? I'll give it 10 more seconds here. All right. So we've got at least one person who's as sick of acronyms as I am, and I get that. But good, it sounds like people want to hear a little bit about trademarks and copyrights, maybe some patents. So just really quickly, I assume that, well, I shouldn't assume anything in either direction, but I apologize if this is just too pathetically basic. But the bottom line is there are three major categories of intellectual property. Trademarks, which amount to the brand of the company, whatever form that takes, whether it's words, the name of the company, logos, sounds, colors, even smells that identify source, the source of your goods and services. That differs from copyright. Copyright looks at original works of authorship. So books, music, plays, photos, software, drawings, anything that an individual authors in one form or another. And note that you could have something that is protected by both copyright and trademark. So a really ornate logo, for example, could easily be protected by copyright as an original work of authorship and by trademark as a brand for a given company. And the third category of intellectual property that we think of is patent, and that covers useful inventions. The fourth area that is less talked about, largely because there isn't a registration system for it, but the fourth category is trade secrets, and that is the secret sauce. Any information that you keep confidential and has value in being kept confidential, including things like mailing lists and the like, could be considered a trade secret. But you don't register trade secrets, you merely protect the information and keep it confidential in order to keep your rights in the trade secrets. The other categories have registration systems, and so they're more thought of when we first think about IP. So that's just a quick primer to get us up to speed, and another quick primer to get us to the new information. But a quick primer is the distinctiveness spectrum in trademark law. So in order to protect a trademark, it has to identify you as the source of your goods and services. And the more distinctive a mark is, the more likely it is to identify source rather than the product itself. So a term that is very fanciful, and the one in the for-profit world that I use a lot, is Kodak. Kodak was a term that had no meaning. It wasn't anybody's name. It wasn't a combination of words or anything. It was completely fanciful and made up. And it came to be very associated with cameras and photography equipment. But it was a very fanciful trademark, very easily protected. On the other end, generic terms are exactly that. They're the generic term for the good or service. So in Kodak's situation, it would be camera equipment or photography equipment and services. In the nonprofit area, just a couple quick examples. A fanciful mark, AmeriCare's portmanteau that has been coined, and the word itself doesn't really mean anything. It may suggest some things, but it has no true meaning and is very protectable as a fanciful mark. On the other end of the spectrum, not quite to generic, but down near that end, is the American Heart Association, which we all know what that nonprofit does and what its mission is. And that's very descriptive. Now, descriptive marks can be registered and can be protected under what's called acquired distinctiveness. So they can be protected if you've used them enough so that they stop being just descriptive of the services, and instead people have come to associate them with your goods or services. Generic marks are a step below that. So what would the generic mark here be? Charity, foundation. You couldn't have a foundation called Foundation and expect to keep others from using the term foundation in connection with their own foundations. Getting tired of saying the word foundation. But the reason that that's important is because a new case came out this year. This was actually one of Ruth Bader Ginsburg's final opinions that she authored, but it was about generic trademarks and domain names. And in this case, the US Patent and Trademark Office that registers trademarks had a policy that said, if you added .com or any top-level domain to a generic term, that doesn't turn it into a trademark. It's still a generic term. And the Supreme Court said, actually, we don't see it that way. And instead, they looked at it and said, the question is whether the term has meaning to consumers beyond just the generic nature of it. So if I were to say that a booking.com is a place where people make bookings, and it could be any company's place where people make bookings, that would be generic. But the court is saying, no, when people say booking.com, they're talking about one company and one company's goods and services. And therefore, it is protectable. I apologize. I think, did I overstep where you were going to talk about, we're in that situation, and now they've gone against the PTO and said, look, these are registrable. But the question that I have, and that many people have is, what rights does this really give the owner of that trademark? Of Booking.com, for example. They're not going to be able to stop me from using Booking in connection with my services that involve bookings. They might be able to stop me from using Booking.co. Actually, I think that would be a very strong case because that's very similar to Booking.com. But what about Booking.info or something where it's, you know, pretty clearly a different term than Booking.com? We're going to have to wait and see how the courts come out on this because the question is always likelihood of confusion, and it's unclear how consumers interpret those top-level domain names. Will they see all of those as emanating from the same company where it's a generic term? Or will they see them as, well, that's not Booking.com because Booking.com's at Booking.com, not at Booking.info. So we'll have to wait to see how this plays out.
So I will take this opportunity to briefly just share why folks may want to consider registering trademarks. And I say that, we'll get into copyright in a minute, but unlike copyright infringement, for trademark infringement, you don't have to register your mark in order to bring an infringement lawsuit. But it is a good idea to do so. So in addition to helping clients with litigation, I also help them stay out of litigation. And one way we do that on the trademark side is, clients will come to me and say, these are the marks or these are terms I'm considering for branding purposes, any issues on the IP side. And one of the first things we do is we look at the USPTO's website to see if there are similar marks. So, and if there are, we go through the analysis, whether, how similar they are, does it matter, what are the chances, et cetera, of infringement, of being accused of infringement. But that public record, the USPTO's website, can discourage others from adopting a similar mark. So you can preemptively, just keep away these potential infringers. I'm not saying all of them will stay away, but you can minimize the potential infringers. Second, there is a presumption of validity. You've got a registered federal trademark, so you can waltz into court and say you got your presumption of validity in terms of your burden of proof at trial. It's now on the other side to prove that that trademark is invalid or it shouldn't have been granted, et cetera. So, and then I will quickly touch on,
right. Before you move on, just really quickly, on the non kind of legalism side of it, in my experience, a couple other benefits of registering your trademarks, even though you're not required. First of all, you get to use that Circle R. Everybody likes it. Donors like it. Consumers like it. Everybody thinks something with a Circle R is kind of more important than something that has a TM. And by the way, if you have a registration, you get to use the Circle R. If you want to claim trademark rights in a term and you don't have a registration, you use that superscript TM. So if you've always wondered about the difference, there you go. Exciting facts for today.
I was just going to say that next. Thank you.
Oh, sorry.
Yeah, because there's a few other benefits, actually. I wasn't...
Go ahead. Go ahead.
Okay. I just wanted to share that the USPTO polices the registrations, right? So when you apply, and this is what Nate does, I don't do this side of things, but when you submit the trademark applications, the USPTO will refuse the registration if it determines that there's a mark that's confusingly similar. So it's nice to have that additional layer of protection for owners of registered marks. Another benefit is that you're entitled to enhanced damages against counterfeiters if your mark is registered. And if your mark is registered here in the US and you want protection in a country for that mark, and that country is a party to the Madrid Protocol, you can also get protection in that way as well. So there are a good amount of benefits to registering your mark.
There certainly are, no question about it. And really quickly, the last one I'll throw in is if somebody is doing something inappropriate on another site using your mark, if you have a registration for that mark, it's much easier to get that information removed, that posting or whatever it is removed. That's not under the law. That's under various companies' takedown policies and their terms of use, but it is definitely a benefit. Having that registration goes a long way. If somebody sets up something that's, you know, not parodying your site or your services, but instead is really trying to pass themselves off in some way, instead of having to sue them in court or take legal action of one form or another, if you have a registration, very often a quick notice to the site on which this, you know, material is appearing can get it taken down very quickly. So lots of benefits to registrations. So we're going to move on to copyright. And again, copyright covers works of authorship, original works of authorship. Just about anything that gets written, drawn, recorded, etc., can be protected by copyright. And much like trademark, but at the same time very different, copyright has a registration system. And Sushila, you're going to touch on this.
Yeah, so the copyright registration is relatively inexpensive. And unlike a trademark lawsuit, in order to bring a copyright infringement lawsuit, you are required to have a registered copyright. I cannot tell you how many folks we've had to tell your mark's not, your copyright's not registered. You cannot bring a lawsuit. This is relatively new law, but it is the law. Let's just make sure. I didn't have, well, so the other point I'll say is that I mentioned trademarks earlier. You have common law rights under trademark infringement law, but here it's a non-starter if you don't have a registration. So if you're choosing between the two, definitely make sure those copyrights are registered.
Yeah, so when we say inexpensive, copyright, I think the fee right now is $45 per work. It's pretty straightforward. You might need somebody to walk, a copyright attorney or paralegal to walk you through once, but once you've seen it done and you know what some of the less than clear language is really asking for, it's very quick and easy. If you were to have to get into litigation, somebody would, really stole something from your website or your software, and they were really causing a problem and you didn't have a registration, you can get an expedited registration in about 2 days. If you really need it, it costs an extra $1,000 or so. So definitely not overly cost effective, but all is not lost if you don't have a registration. But if you have a registration prior to the beginning of an infringement, you have a lot better access to damages. So first of all, you don't even have to prove up damages. You can get statutory damages. Secondly, you can get attorney's fees. And third, you can get enhanced damages where you can show that they were willfully infringing. So it's really worthwhile to have that registration in place to the extent that you have books or, a lot on your website that's really the kind of thing that somebody would take, copy, and post somewhere else. And it should be noted that there's a new volume registration process available. So one of the questions I would get from clients all the time is, well, we add stuff to our website every day. How often do I need to register it? And, depending on the company, I might say, well, for $45, register it every day. It's just worth it. But some companies would say, no, we're just not going to do that. Well, now you can actually do a volume registration where you register up to, I can't remember the number, but I'm going to guess it's somewhere in the range of 750 works at a time. So to the extent that your website includes, various items that are added at different times, you can register a lot at once and not worry about getting that daily update. Now, you're still going to have the issue of when you registered vis-a-vis when somebody infringed, and you'll have to consider that. But you still at least have this option for volume registration, which does make things a lot easier. And the last thing I want to talk about in copyright is not a new issue, but it's one that I raise all the time with clients because it's really an important one. The works made for hire doctrine is an important copyright doctrine. And what it basically says is that if something is a certain type of work and it's created by a third party, and you hire the third party to create this thing, and you have a contract that says it's a work made for hire, then you, the hiring company, gets to be the author of that work rather than the person who actually physically wrote it or created it. And so that's very valuable for a number of reasons. And I'm not going to go too deeply into it, but it is valuable. The problem with it is that the Copyright Act very specifically defines what can be a work made for hire. And the classic example is a film and any part of a film. And the reason they did that was because when you look at a film, you've got many people that are contributing separate works. So you've got a sound recorder, you've got a different person holding a camera who is, the author, if you will, of the film that's recorded. You've got writers that are writing that dialogue. All of those pieces become a part of that film, and all of those separate people would need to do assignments, and it would be difficult to get that copyright in that one unit to an entity. So the copyright law takes that into account and says, okay, we did this work made for hire doctrine. So all you have to do is have a contract that says it's a work made for hire. But again, only certain things fall under the work made for hire doctrine. And I will tell you that very rarely, unless you're a film company or a map maker or the like, or if you're hiring somebody to write a foreword to a book or things like that, very rarely will it actually fall under the work made for hire doctrine. So I don't like to see it in agreements. And more importantly, I don't like to see it in agreements because California has law that says if you have an agreement with an individual and it says that what they create is a work made for hire and it uses that language, the hiring company will be subject to certain employment laws vis-a-vis that individual. Suddenly you will owe that individual certain benefits. You may owe payroll taxes, things like that. So the bottom line is, if you're hiring individuals to create things for you, don't call it a work made for hire. Instead, just include an assignment and have those copyrights assigned to you through the contract rather than relying on the work made for hire doctrine. Okay, that's the end of my rant. So really quickly, we're going to talk about patents. And the question here is, who owns a patent? Well, the inventor owns a patent. So the question came up recently, well, what if it's created by artificial intelligence? There is no person. It's actually a computer program that invented this process that's very useful and very protectable, but there's no person. Well, the USPTO looked at this and said, first of all, AI systems cannot be credited as the inventor of a patent. It has to be a natural person, not any computer program, not any piece of technology. A natural person is the only thing that qualifies as an inventor of a patent. All right, well, does that mean there's no inventor and no patent protection? Well, not really. At least at this stage, there's likely to be a lot of human involvement. Whether it's taking what the computer spits out and making it truly usable. And everything that we've seen so far says that that involvement is going to be sufficient to have that person deemed to be the inventor. But at the end of the day, as technology moves forward, the patent law may not be keeping up and may have to change at some point, but that's one to wait for. So that's just a little patent tidbit to end with. And we really appreciate you coming. And if anybody has any questions, I know there were a number of questions and I hope they were answered. If we didn't get to your question, please don't hesitate to ask now, and you can ask whether on microphone or in the chat, or don't hesitate to reach out to either one of us with questions.